Welcome to the SAminingDesk, your essential partner in understanding South Africa's mining sector. We're a platform dedicated to simplifying the intricate world of mining, from government regulations and groundbreaking judgments to essential industry reports. We deliver clear, concise information to equip you for every step of your mining journey. Join your host, he unpacks the mining sector for us.
Hi everyone, and welcome back to SAminingDesk, your partner in navigating South Africa's mining sector. In our previous episode of The Case Files, we unpacked the Gauteng Chrome Mine versus Minister of Mineral Resources and Energy case, where the court emphasized that consultation with existing right holders before granting a new right for a different mineral on their land is mandatory, and that the actual existence of the mineral being applied for must be confirmed before any right is issued. That was quite an insightful discussion. Today, we're diving into another important case, this time about a mining company that started operations without proper authorizations, making those activities unlawful, and how a neighboring landowner tried to stop them. We're talking about Gideon, Petrus, Anderson and Another versus Silver Unicorn Coal and Minerals Pty Ltd and Others. The judgment was delivered on 16 May 2025 in the High Court of South Africa, Gauteng Division, Pretoria, by Judge S.K. Hassim. The applicants, Mr. Gideon Anderson and his wife Johanna, own several portions of the farm Olifantslagte 378 JS in Mpumalanga, where they live and run agricultural operations. On the other side, we have Silver Unicorn Coal and Minerals Pty Ltd, a mining company that already held a mining right over parts of the same farm. The company later got approval to extend its mining area to include, among others, Portion 3 of Olifantslagte, land owned by another company, All Farms Pty Ltd, which happens to border the Andersons' property. In January 2023, Silver Unicorn began open-cast coal mining on Portion 3. That's when the conflict began. The Andersons went to court asking for a final interdict, basically a court order to stop Silver Unicorn from mining on Portion 3 until it had 1. A valid water use license from the Department of Water and Sanitation, and 2. A proper environmental authorization, EA, from the Department of Mineral Resources and Energy.
There were several intervening parties. OLF Mining Pty Ltd, contractor appointed by Silver Unicorn. Their relationship is that of a holder-contractor relationship. Calamin Pty Ltd, financing the mining activities under a written agreement between it and OLF Mining. Both oppose the Andersons' application, essentially aligning with Silver Unicorn. OLF Mining and Calamin, they counter-apply for a structural interdict in the event the mining operations on Portion 3 are interdicted. Conversely, Menar Capital Pty Ltd, another mining entity, supported the Andersons' request for an interdict, as Menar itself had proprietary interests it sought to protect by having the unlawful activities stopped and by attempting to expand the relief to other portions of the farm.
The applicants argued that, without these approvals, Silver Unicorn's mining activities were unlawful. They also said the area being mined is environmentally sensitive and that unapproved mining there could cause serious and irreversible harm to the environment, their farms, and nearby communities. Silver Unicorn admitted it started mining under the mistaken belief that its existing environmental authorization and water use license already covered Portion 3. Once it realized the mistake, the company applied for Section 24G rectification under NEMA to correct the unlawful start of operations and also applied for a new water use license in April 2023. Interestingly, none of the government departments involved, Water and Sanitation, Mineral Resources and Energy, or Agriculture, Rural Development, Land and Environmental Affairs in Mpumalanga, took part in the case. To succeed in getting a final interdict, the Andersons had to prove 3 things. 1. That they had a clear legal right. 2. That there was an unlawful interference with that right. And 3. That there was no other satisfactory remedy available. Let's look at how the court assessed each of these. 1. Clear right. The court said the Andersons didn't clearly identify which legal right they were trying to protect. It seemed their argument was that since Silver Unicorn was mining unlawfully, they had a right to stop the company. But the judge pointed out that the National Environmental Management Act, NEMA, the Mineral and Petroleum Resources Development Act, MPRDA, and the National Water Act already set out how to handle unauthorized mining or other regulated activities. These laws also give companies an opportunity to rectify any unlawful actions. The court referred to the old case of Pats versus Green, 1907, which basically says, where legislation prohibits an activity that affects the public, no person has a right of action against another merely because the prohibited act was done. The person complaining must show they suffered some special damage, a harm beyond what the public suffers. But if the law clearly protects a specific party, special damage need not be shown. The court found that NEMA, the NWA, and the MPRDA fall within the category of laws that protect the public as a whole. The judge was not satisfied that the Andersons had shown any special damage. The court also referred to Interwaste versus Cotees, where it was found that the mere failure to obtain a license does not automatically establish a clear right for an interdict. The clear right must come from the applicant, not from the respondent's failure to comply with the law. In other words, a person cannot simply play policeman and try to enforce laws that fall under the responsibility of environmental authorities. In Lasky and Another versus Showzone CC, the court similarly found that where legislation is enacted for the public benefit, an applicant must show actual harm or reasonably apprehended harm to succeed. So, the judge concluded that the Andersons failed to prove a clear legal right deserving protection.
2. Unlawful interference or reasonable apprehension of harm. The Andersons argued that the mining would harm the environment, water resources, wildlife, and their farming operations. They presented a report from environmental specialist Miss Katharina Bozeman to support their case. Silver Unicorn countered with its own expert, Mr. Van Staden, who disagreed and said the mining's impact was not as severe as claimed. The Andersons then brought in another expert, Mr. Johanna Marie, who sided with Bozeman. Because the experts disagreed on key facts, the court found that there were serious factual disputes that couldn't be resolved based on the papers alone. In the end, the judge said the Andersons' report was too theoretical as it focused on mining in general rather than the specific operations on Portion 3. As a result, the court wasn't convinced that the mining actually interfered with any of the Andersons' rights or that there was a reasonable fear of harm. 3. No other remedy. The court found that both NEMA and the MPRDA already provide mechanisms for dealing with unlawful mining, including measures to stop or correct such activities. If the Andersons believed Silver Unicorn was acting unlawfully, they could ask the relevant government departments to enforce the law. The court concluded that the Andersons failed to prove all three requirements for a final interdict. Their application was therefore dismissed, and each party was ordered to pay their own costs. And that wraps up today's case file. Thanks for watching SAminingDesk. In our next episode of the Case Files, we'll look at Sandhawks Pty Ltd and Another versus Labont 5 Pty Ltd and Others, a case that clarified the regional manager's role in accepting applications under the MPRDA. See you then!